It's time to listen in to the stories for Crossroads of Business and Family on the Got Family Show with Carrie Berger. Whether you're in the business of your own or want to be, this is a show where changes happen. Now, here's Carrie Berger.
Hello, and this is Got Family, and I'm Carrie Berger. We are here on thevoiceoflawrence.com, and today we're going to have a little different format than normal. We're going to have a guest with us. We'll be doing that after our first break. For now, though, as usual, I'm going to tell you about my week. This week, I've spent working with a family that, as is usually the case, that is dealing with someone in their life who is, let's just say, causing some trouble. They have a business that has real estate, and amongst the real estate, they've got a tenant who runs another business within that. I'm trying to be really vague. As you know, I always try to maintain the privacy and the security of every individual. I mean, I'm not going to tell you names or states, but so anyhow, you get the idea. Point is that what's happened now is there's a conflict. There's a conflict between this tenant and this landlord in this business setting. And they're trying to figure out how do they get past this and through this. And it's gotten to the point where the other side, in this case the person who's running the business within the real estate, is engaging an attorney. They have threatened all sorts of lawsuits. And it brought to mind a discussion I think is just mildly interesting, and maybe you'll find it's interesting too. The discussion is libel and slander. In this particular case, the gentleman has said, well, you've said bad things about me, okay, or you've written bad things about me, which would be the other part of libel and slander, and for that reason, I'm going to sue you. And he's actually found an attorney who's willing to write them a really nasty letter telling him all these things, which is interesting. The reason why it's interesting is this. Of all of the topics in the law that wind up being abused by people who don't know the law, libel and slander is maybe number one. It's so easy to say, you said bad things about me, it's not true, I'm going to sue you. The reason why it is not really a practical solution is because the ultimate defense to this particular charge is to prove or establish that this is the truth. I may have said these things, but what I said was not libel or slander because it's the truth. Okay, what does that mean? Well, what that means is that you go into a courtroom in that setting, if somebody actually goes so far as to actually take you to a courtroom, and you get a chance to talk on and on about all these terrible things that this bad person is or did, and try to say that they're true. It's really, really unpleasant. It, generally speaking, because it's going to involve so many he said, she said, is almost impossible to prove anyhow, whether it was true or not true. So unless you said something very, very specific and very provable as being not true, you just kind of get your chance to say nasty things about them in front of all their friends. Not a real pleasant experience. So for that reason, most of the time, when you wind up with a charge or somebody who's saying, hey, you've done this to me, this one doesn't ever go to court. It just doesn't. Usually you can't find an attorney who will even write the letter because they realize this is going to a path someplace that ends badly. But nonetheless, my advice is this in this situation. If ever you find yourself in this situation, obviously always, do what's right. Your mother was correct when she said, tell the truth, be nice. That's still the truth. That's still appropriate. If you find yourself in a situation where someone is charging you in this, chances are they are being the classic third grade bully that you faced when you were in the third grade. They believe that they can threaten you, they believe they can scare you or intimidate you, and they're picking on you because they believe that you'll follow the rules. And so the threat of this charge is going to intimidate you into doing something different. Ultimately, your best defense is going to be just keep doing what you're doing, be honest, be kind as best as you can. Don't fall into the trap. Don't go down that path, so to speak. Take the high road. And if indeed you find yourself in a court, have a great time because quite honestly, they ask for trouble and you get to deliver it. So anyhow, that was a mildly interesting discussion I wound up having today, not on the topic that we normally think of as where the crossroads of business and family intersect, but in this case it was because this gentleman was dealing with a very real threat to his family and the perception that he's going to deal with this possible lawsuit, and it all came about because of his business relationship with the tenant. So maybe some of you have been in this situation. I'm not giving you legal advice that you should not follow other local counsel, get support, but don't be too afraid. It'll be okay. Well, with that being said, let's go ahead and take a break, and when we get back, we'll be talking to Stephen Ware. He's a professor at the University of Kansas School of Law, and we're just going to have a conversation today. So we'll see you in a moment here on the Got Family Radio Show. Welcome back to the Got Family Radio Show. This is Kerry Berger, and with me is Stephen Ware, again, a professor at the University of Kansas School of Law. Hello, Steve. How are you today?
I'm very good, Kerry. Thank you very much for having me. I really appreciate it.
Today we're going to literally just have a conversation. The topic will go where it goes, so I apologize in advance if we ramble, but that's part of the fun, isn't it? We're talking about anything that has to do with that crossroads of business and family. One of the things that we can talk about, I guess, is kind of what is your specialty at the University of Kansas? Tell us what you do and kind of where you come from.
Yeah, I'm a law professor, so I teach law school, and the areas of law that I'm connected with, that I teach and write in, that really are at the crossroads of business and family, are issues relating to consumers. We're all consumers, we all buy things, and many of us incur debt. Consumer law governs debt that individuals and families acquire for business purposes or for consumption of their credit cards or their home mortgage or whatever it might be. And unfortunately, some of the debts are not repaid, and that can be for a variety of reasons, and sometimes that leads to difficult debt collection issues, which I study from both the perspective of the debtor who owes the money and the creditors trying to collect the money, which we see in the business context for sure, as well as in the personal and family context. And sometimes folks and businesses with significant debt problems end up in bankruptcy, which is another area of law that I teach and focus on. So really the financial side of consumers and debt and how that plays out with their businesses and their careers and their personal lives, it all ties together.
Well, we all do live in that place where money is part of our life, for good or for bad. And I do want to talk about both sides. Let's talk about it both as the business owner, where somebody owes money to you and they're dealing with their debt and you are the debt. And, of course, from the other side, where as the individual or the business owner, you have purchased things and you are the debtor, and you're dealing with that debt. Which one do you want to start with?
Terrific. You put it in a good order there, which is you started with the creditor. You started with the person who's owed money or business that's owed money. And I say that's a good order because the way our legal system is set up, as you know, is that if nobody takes any action, then courts don't do anything. And so if you're not getting paid, if you're owed money, the burden's on you to take some action or you're going to remain unpaid. In other words, maybe you're going to have some non-legal way to persuade your debtor to pay you. Maybe you can send a letter.
We're not involving Guido, by the way, just so you know.
No broken legs or threats to do anything like that. Maybe you can use ways that don't involve lawyers and courts to collect. Maybe you can use credit reports. Maybe you can use negotiation. But if you do need to resort to lawyers and courts to collect debt, you're going to have to start that action. You're going to have to bring a collection action in court. Or if you're like some lenders, you have collateral for your loan. Clearly, home mortgage lenders have homes as collateral. There's business real estate that's used as collateral for mortgage loans in the business context. We all know about Repo Man and car loans, right? People's cars getting repossessed.
Well, let's go ahead and assume that we're talking about someone who's not secured. They've got a client. They don't have a particular asset that they can attach. How fast do you have to switch over from being do nice guys really get paid last?
This is an unfortunate reality, right? Which is if you're good at your business, you're probably making sales. And making sales is often the nice guy. And making sales is often we provide our services or our goods before we get paid for those services or goods, and you're just hoping to collect payment voluntarily that your customers will pay and that they'll pay quickly. On the other hand, if you talk to most small business people, they can tell you stories about customers who don't pay quickly or don't pay at all. And then we're going into that topic we started on a minute ago of what are the ways short of hiring a lawyer to get paid, and do they work? So in your experience in working with clients, I'm curious, have you seen folks, well, I guess a better way to say it is, what approaches have you seen folks use successfully to collect what they're owed, short of going to litigation?
Number one, of course, is really kind of guilt. Pretty straightforward. Would your mother be proud of you? Kind of discussions, if you will. This bill is owed. We need to pay this. And interestingly, most of us as business owners have one of two types of businesses. We either have a business where we have lots and lots of people that we have sort of very superficial relationships with, and they don't have a connection or a commitment to us, or we have fewer number of clients with a deeper relationship. That really is the big distinction. If you are in the first category where you've got all these superficial relationships, there's really no amount of guilt that's going to have any impact upon that person. If you do have a deeper relationship, sometimes there is a difference, and then it's just, you need to pay this, it's time, what can I do to help, let's try to be understanding. But it really is a real concern, is trying to make sure nice guys don't always finish last. We've all faced that. I think everybody has.
Well, you make a hugely important distinction there between businesses that have a small number of clients or customers that they've developed relationships with, and there's that level of trust and conscience between them that is more likely to result in that responsible behavior you describe. Even folks who have a hard time paying for good reasons, that they're just having financial hardship, that they're kind of working it through with their creditor and will eventually get around to paying when their situation rebounds. And we all know folks who are just good humans and say, I realize you're having a tough time now financially, I'll give you more time to pay, because they have that sort of relationship.
Now at that point, when do you cross the line where, as the business owner, or in this case I guess the creditor, that you've harmed yourself by giving them more time? I mean, when you need to cross over into other options, when have you accidentally made it harder on yourself?
Well, you raise a really important legal point now, and it gets back to your nice phrase, nice guys finish last, which is the way law works when a debtor has insufficient income or assets to pay all his creditors. It's basically a first-in-time rule in the law, which is the more aggressive creditors, the people who sue first or took action first, are more likely to get paid, and those who are slower, you might say nicer, are ending up at the back of the line. And so there really is an incentive in the law to be the more aggressive creditor, but obviously we wouldn't want to advise businesses to be quick to sue their customers, right? That's not good business practice, as well as good just interaction with your fellow human beings. So you really do identify a difficult trade-off there for a business owner that's owed money. When do I have to start toughening up on this customer?
Is there a magic line? Is there a 6 months, 12 months? There's this, you hear the word statute of limitations. Is there some place where we run into that?
Well, that is the ultimate lawyer's line. Typically 4 or 6 years on a contract debt. So if somebody's not paying you that long, you probably given up. You're probably caught on by that point.
Yeah. Well, we've caught on also that it's time for us to take a break. So we'll return with Stephen Ware from the University of Kansas School of Law right after this break here on the Gott Family Radio Show. Welcome back to the Gott Family Radio Show. This is Kerry Berger, and I'm here with Stephen Ware from the University of Kansas School of Law. And we are having a little conversation about money and how it impacts your life, both as the creditor, the one who is owed the money, and as the debtor, the one who may owe the money. For now, we're staying on the topic of being the creditor. So again, you were just talking about the idea that there are timelines that cross. You said 4 to 6 years. What is it, 4 or 6?
Well, it depends on the type of contract, and this is why you hope you don't have these kind of problems get to the point of where it's litigation that you've allowed to be delayed so long that you're in the statute of limitations question. In other words, did you sell goods to your customer, or did you provide services to your customer? Those kind of questions
So
could
goods
determine goods more likely to be 4 years and
Okay.
services more likely to be 6 years, but this varies from state to state. And as with anything in the law, there's exceptions. So there's times where people say, well, the clock doesn't start running until, so even though you sold the goods on this date, the clock didn't, So we can get into arguments in
We'll
the
go
law
ahead.
about just
Tell you
about
what we'll
anything.
do. We'll just do it this way. We'll say, if you're getting close to 4 years, you better be looking really closely at whether it's time to engage an
That's
attorney
good.
and start
That's
moving
good
forward.
advice.
Is that fair?
That's good advice.
Uh,
And if you do ultimately have to sue somebody who owes you money, it really does vary depending on the dollar amount. In
I was
other
gonna
words,
ask that
in Kansas and in I think every other state, there are small claims courts that only allow cases below a certain dollar amount claim, typically about $4,000, although some states go up to $20,000. And this is an easier way for a non-lawyer to represent him or herself in court and win by just telling the story to the judge in an informal way where you don't have to know the rules of evidence and technical things. And that becomes much more difficult at the higher dollar amounts, where you probably will have to hire a lawyer. And what's key here is if you are a bank that issues credit cards, then you're a repeat player. You have a lot of debtors that are not paying you, and so you have economies of scale in having collection department and hiring a lawyer and all. But if you're an individual small business person, you don't have that kind of economy of scale going for you. And so you really do have to trade off the time and money it takes to win money. You certainly don't want to be spending $6,000 to collect a $4,000 debt.
Well, I actually want to talk about that from 2 points of view before we get to the break and switch over to being the other side. One of them is, when is it worth the time and money? How does the economy of a single case actually work? Am I going to spend my life savings trying to collect a pittance? Where's that piece of it? And then the other piece of it is, I kind of want to skip clear past how do I win or lose, because that is kind of the place where the lawyers are going to live, and we're going to deal with that later. But okay, let's say I win. What do I get, and how do I actually get the money? Because those are the parts that really matter. I mean, you can have this piece of paper that says anything you want to, but do I get any money is the question. So let's do the first part first. When should I start to think about either small claims court and the time and energy it's going to take me to get it done, or hiring an attorney?
Yeah, your caution is very wise. I can think right off the top of my head of 2 stories that fit that caution perfectly. One of them is a local story right here in Lawrence, and I will follow your lead of not giving enough detail that anybody can tell who we're talking about, but it was another landlord-tenant sort of dispute where there were really just a few $1,000s at issue. And one side did end up hiring a lawyer and ended up spending about as much money to collect as they got out of the process. And there's a lot of anguish that goes in that. Nobody likes to be a litigant in court. It's fighting, it's stressful, it's not fun. So that's at the small dollar amount level, a kind of a cautionary story. And then I can think of some folks in another state that I've worked with recently who had $200,000 owed to them. Big enough money to hire lawyers and fight about, but they ended up spending so much money trying to collect the $200,000 they owed, and of course they won in court. But then your second point kicks in, which is great. You won in court. You've got the court's ruling in your favor. That didn't actually put any money in your pocket. It's now enforcing the judgment that the court has issued for you that the real challenge begins.
We're going to get to that in just a second. Actually, I have a truism that I use, by the way, with my clients. Whenever they give me a story about I'm in this situation, this is happening, and whenever I can translate their words into something that sounds like or could be worded as it's the principle of the thing, I immediately say, if it's the principle of the thing, then that means it's not economically going to be viable. As soon as you've crossed over to where you're not doing this because it's a business decision, it's the principle of the thing, then you have to know you are paying for the privilege of this principle. And you have to decide, how much money am I willing to spend to be able to say it's the principle of the thing? And rarely, if ever, are they a good business decision. Would you agree?
I definitely agree with that. And you and I are both principled people, but I think each of us would say we've seen enough people pursuing principles in disputes that when they look back on it years later, they say, you know what, I would have been better off if I had just let it go.
Yeah, and it hurts. It's hard to do. I have been a part of that myself, and emotionally to be able to not say, but they did this wrong, that this shouldn't have happened, and I should be able to make this. Yeah, but if I'm going to wind up, how much money am I willing to spend for the privilege of having that righteousness, which by the way may never come, because after all, once you get in the courts, then there's other things going on. But let's switch to the last piece, which I think is where we should go before the break, and that is great. You got this piece of paper, you get the money, isn't that awesome?
Well, when you got the piece of paper, how do you get the money?
When do I get to cash the check? Exactly.
And
where's my check?
And so the basic law on this is state by state. It varies from state to state. But the usual routine, as I said earlier, is if you have collateral, if you're a home mortgage lender or a car lender with collateral, then you're in a much better position to foreclose on the real estate or to repossess and sell the car. But if you're the typical small business person who doesn't have collateral, you're just owed money on a plain old contract, a plain old agreement, when you win in court, the debtor's property, whether it be the car or the house or anything, is not automatically going to you. You're going to have to go through further efforts to get it. And a common vehicle to do that is garnishing wages. It works here in Kansas, it works in many states, not all. Some states protect wages from garnishment. But in most states, including Kansas, the clerk of the court that awarded you a judgment will serve upon, or help you serve upon the employer of your debtor a garnishment order. Now, if your debtor is not an employee, maybe your debtor has a bank account that you can garnish. But if your debtor is itself a business that's collecting its own customers' debts, that's a much more complicated process. And there are some cases where the successful creditor who won in that lawsuit gets a order to the sheriff to go out to the debtor's location and take stuff from the debtor, and the sheriff sells this stuff and gives the money to the creditor. But it's pretty rare that happens, because Kansas law, like every other state, allows debtors to keep some property exempt from that process. And that's probably a great transition to the other side of the story.
That'll be the transition on the other side, is going to be what happens if they seek bankruptcy protection, or if you seek bankruptcy protection. I think that is where we'll stop for now. We'll take another break. When we get back, we'll look at the other side of this equation of how do you protect your assets, and we'll, by virtue of that same side, be able to look at how does that impact those who are on the creditor side when someone has sought and achieved bankruptcy protection. So this is Kerry Berger with the Gott Family Radio Show on thevoiceoflawrence.com. Welcome back. This is the Gott Family Radio Show, and I am Kerry Berger. We're here with Stephen Ware of the University of Kansas School of Law, and we're continuing to talk about your money and what it means when maybe there's not quite enough of it on one side or the other. We're going to kind of switch sides now, and we're going to talk a little bit about being the debtor, the person who owes the money. That will tie us back to what it means for the person who's the creditor too. So let's assume for a second that, yeah, these things have gotten out of hand, we're in trouble. When do you pull the trigger? When do you pull the ripcord, so to speak, on this thing? You know, okay, I owe 2 pennies more than I have, so I should immediately call bankruptcy, or is there something more to it?
Well, the standard story is that people try hard to pay their debts, and I believe that's true. I think there's very few people out there in our society, fortunately, who are trying to shirk financial responsibilities. So it's good folks who are trying to make ends meet generally. Sometimes people get carried away buying things they can't afford. We're all human, we all make mistakes. But generally people's hearts are in the right place. And so people tend to feel some shame, like they failed if they have trouble paying debts. And the problem with that, besides the internal bad feelings they're experiencing, is it can lead them to hide from their creditors, instead of to face up to the hard reality of I owe more money than I have to pay. And that tends to make problems worse. So the first advice I would give folks with debt problems is please try to bite the bullet and deal with the pain now. Get hard conversations with your creditors. Call them up, speak to them directly, don't hide from them, explain to them your challenges, try to work something out where you get more time or you get to reduce the amount you're owed. Creditors tend to be pleased with debtors who are upfront and work with them that way, as opposed to debtors who run and hide from them.
Well, and that's a great distinction, because in many ways, the run and hide behavior, I mean, there are, unfortunately, folks out there, and unfortunately probably most of us as business owners have bumped into some of them, that really don't take their obligations seriously, and so it does feel like as if they're just thumbing their nose and hiding behind the protections that are supposed to be there for good folks. But there's also really good folks out there that legitimately are having some troubles, and they are ashamed, or they are concerned, or they're afraid, or whatever, and they just say, well, I'll keep my nose to the grindstone, my head in the sand is unfortunately the other half of it, and I will not deal with this right now. And you're right, facing it earlier is going to make it so much better, and we see that on a regular basis. So much of this stuff can be figured out before it kind of tumbles down the wrong path, for everybody's sake. So yeah, I really like that advice, to just start by facing it, dealing with it, be honest. Most people on both sides are going to be good people and try to help you out. But let's assume for a second that we get to a place where, all right, we've faced it, but unfortunately the numbers still don't add up, no matter how much we face it. Then what happens?
Well, usually push comes to shove for a debtor who's overstretched when wage garnishment that I mentioned before from the creditor's perspective happens. In other words, if a debtor's having trouble making monthly payments with the full wages, once some of those wages get garnished and are no longer going to the debtor, now it's not possible at all. Or what you see is repossession of a vehicle. If you're not making car payments and your car gets repossessed, well, now how are you going to get to work is a common problem. So you sometimes see a disaster on the financial side like that. Income gets cut either because of garnishment or unemployment. A lost job can be the disaster. Or sometimes you see what I'll call non-financial disasters that have a financial effect, which is typically a big medical problem in the family or a divorce or breakup in the family. Those things tend to be the straw that breaks a lot of financial camel's backs, so to speak. And that's where you do see folks consulting bankruptcy lawyers and filing for bankruptcy.
Now, in that situation, okay, let's take this just a second down the road, so to speak. So I realized that I've had this thing happen. My job has been lost. My relationship has been lost. I've had a problem in my world, and so now I'm going to have to go down this path. So everything's going to be all better instantly, right?
Well, filing for bankruptcy can make some things better instantly. I have to say that's true, because there's a 4-letter word in bankruptcy called stay. As soon as you file for bankruptcy, your creditors are legally obligated to stop trying to collect from you. That's the stay in bankruptcy. So that really is instant relief. However, that's not going to last forever. That's only going to last for a few months while the bankruptcy case gets worked out. And then the crucial question is, how much of your debt will you be able to discharge in bankruptcy? Discharge is the legal word for I no longer owe it. I don't have to pay it anymore. And there's basically two kinds of debts that have different rules. We talked earlier about collateral for loans, secured debts, versus loans where there is no collateral, unsecured loans. And basically the rule with unsecured debt is you can discharge it in bankruptcy. You don't have to pay it anymore. There are lots of exceptions to that, as with anything in the law. There's types of debts that are not dischargeable, like student loans are a famous example of that. But if you have credit card debt, for example, probably you will be able to discharge it. So we see a lot of examples of sort of simple bankruptcy cases where somebody might owe $20,000, $30,000 to credit cards and other unsecured debt, and maybe it costs them $1,000 or $2,000 to file for bankruptcy because you got to pay a lawyer and pay a court fee, But then you've discharged that $20,000 or $30,000 debt, and you can move on with life with hopefully a more manageable financial situation. And real caution about not going down that same path a second time. First of all, because it's a bad path to be on, but second of all, you won't be able right away to file bankruptcy again and get another discharge. You're going to have to wait many years if you ever want to be a repeat bankruptcy case.
Well, there's lots to think about, and I'm thinking about it, of course, from both sides, because, like you, we are all living at that crossroads of business and family, and I'm thinking about, I'm the business owner, and the person suddenly got to put me, back on my heels, and I don't get to collect on something that I provided the services, I provided all those things, but yet I'm unsecured, and so they just get to walk, and it feels kind of scot-free. On the other hand, I also see the other side, which is I'm the individual or the business that's done their darndest to be able to pay their bills, and unfortunately the numbers are not going to add up, and it's time to be able to get a fresh start. And that really is what it's all about. I think that was the purpose of bankruptcy, was fresh start, chance to work and earn the chance to do this again. Do this again, not bankruptcy, do this again as in working and earning and contributing to society and your family.
Exactly right. I mean, there's a strong case for the fresh start in the sort of America as this entrepreneurial place where we're allowed to have second chances and restart our lives, and great stories of business owners who failed once or twice, but then they did something that we all value, the third or fourth time, and thankfully they were able to get out from under their financial challenges earlier to do that really positive thing.
And we'll talk more about that after the break. This is Got Family, and I am Kerry Berger. We'll see you in a moment. Welcome back. This is the Got Family Radio Show, and I am Kerry Berger, and this is Stephen Ware. Again, he is a professor of law at the University of Kansas, and his specialty has to do with your money, and that's what we're talking about right now. We're still talking about bankruptcy, or the potential thereof, and we're kind of talking about it from the point of view of the debtor, the person who owes the money. I say kind of because each of these things does have a different point of view. I'm thinking about it for just a second. Okay, so again, I've done my best. I provided my services. I'm a business owner. I thought the person was going to pay me. It seems like as if there is a strata of the world that says, well, I am creditor proof. You can't take it from me because I don't have any assets that are not protectable. Talk about that a little
Sure.
bit.
There's a hard reality in what you said, and I start with that old saying about don't put all your eggs in one basket, in the sense that if you think about the credit card issuers, the banks with hundreds or thousands of debtors, they don't have all their eggs in one basket. They've got thousands of baskets out there, and they have pretty good ability to predict, well, 90% of our debtors will pay in full, and these 10% won't, and we build that into the interest rates we charge, and we're going to make a reasonable profit when the world goes as it usually goes. But if you're a small business person with a lot of eggs in only a few baskets, if you've got a small number of debtors who owe you a lot of money, then you're right, it's a real big hit to the creditor. a debtor who doesn't pay. And so a lot of good counsel to those sorts of business people is, how do you exercise appropriate caution without scaring away customers?
Wow, very good point there. And that, again, comes kind of down to that nice guys finish last, or no good deed will go unpunished kind of concept. Okay, so let me get this straight. You need the services, I'm going to provide the services. You need more services, I'll provide more. You really need them, but that may be the whole reason why you're not going to pay for them. And you're right, at some point you're just going to have to kind of use your own common sense and make a good call. And unfortunately, as sad as it sounds, sometimes you have to make a call to say, yeah, I realize that this person needs that, but I can't do this unless I am confident I'm going to get paid. And if I'm not confident I'm going to get paid, I may have to look at it differently. Is that accurate? Would you say that's where it really happens?
There's nothing wrong with asking for payment up front.
Yeah.
If you can stay in business, if your customers are willing to do that, then ask for payment up front, or at least some of the payment up front. I mean, it's such a simple way to collect the debt is to not be owed a debt in the first place.
Yeah, good point. Well, let's go back to being the debtor now for a second. And again, we've done everything we could. We've run our business the best we can. We've lived our life the best we can. And things just went sideways for any number of reasons that we couldn't predict. You talked about the immediate protection of the stay. Once I get through the stay, then at some point I got to deal with it. You know, you hear about two different types of bankruptcy. Can you just tell me about the two different types?
Sure. We in law use the names Chapter 7 and Chapter 13. That's the part of the bankruptcy code. But the way to think of it is the debtor paying with his or her property, or is the debtor paying with his or her future income? Chapter 7 is paying with your property. Chapter 13 is paying with your future income. So if, I think we used the example of a $30,000 in debt previously, if the debtor has very little property at the time he or she files for bankruptcy, if it's a sort of a bare bones existence, the law is going to protect that property for the debtor to keep, and none of it will have to be sold to pay the $30,000 creditors. And so that's where our sympathies go to the creditor that you talked about earlier, who's taken a big hit. On the other hand, if the debtor has non-essential property at the time of filing for bankruptcy, like maybe a boat, something for recreation, then the bankruptcy process will have that property sold with the money going to pay the creditors. So maybe if the boat sells for $10,000 and the creditors are owed $30,000, all the creditors will get paid a third of what they're owed, is the basic idea of Chapter 7 bankruptcy.
On Chapter 7, we think of that as kind of the clean slate, or we wipe it away and it's behind you and it's done. And then we talk about protected assets. The classics that we all think about would be a home, a car, the tools of the trade. Tell us what that means.
You've got the Kansas law exactly right there, and Kansas is unusual. There's only, I think, about 6 or 7 other states that allow a home of any dollar amount.
Wow, so I could have a $6 million home.
I don't see many $6 million homes, but I suppose that's right. The exception to that is the home mortgage. In other words, if there's a mortgage lender, then you don't pay your mortgage, you're going to lose your $6 million home.
Gotcha.
But if we're talking about that $30,000 in credit card debt and so forth, in Kansas, those creditors cannot touch the debtor's home, no matter how expensive.
How about the car? How expensive can my car be?
Their $20,000-$25,000 car is still a nice car. It's not a $6 million home, but it's still, compared to some other states across the state line in Missouri, it's going to be a much cheaper car. And so you do
Usually
see.
it's in Missouri.
So you do see what's called pre-bankruptcy planning. In other words, most debtors with financial trouble, they don't have this problem of assets. They're trying to scrape by with the little bit of pots and pans and clothes that they have. But the debtors who do have the boats and the cars worth $30,000, $40,000, you often see them planning ahead of time before filing for bankruptcy, so those assets are no longer around at the time of bankruptcy.
And they get absorbed into the big house that they then pay down the debt on the
yes,
house.
there's legitimate ways to do that and illegitimate ways to do that. For example, if you were to make a gift of your boat to a child, a relative, that would probably not succeed in standing up. On the other hand, if you just need money to pay your mortgage and you sold your boat to pay the mortgage, then yeah, that will probably
How about if
work.
you're paying down principal on the mortgage?
Yeah,
Even
that'll
then?
probably work. Yeah.
So you sell $40,000 worth of your boat, and you put all of it against your principal, so you reduced your mortgage, and now it's all protected.
Now,
Because
you make a good law professor, Kerry, because that's exactly the kind of difficult fact pattern that we work through, because it's difficult for courts. In other words, you're making facts that really start to smell a little bad, and the closer in time that he's selling his boat to when he's filing for bankruptcy, the worse the smell gets.
And some of these things do really smell, and unfortunately we're smelling the end of our break for now, so we're going to take a break again. We'll be back again briefly with Steve Ware of the University of Kansas School of Law. This is Got Family, and I am Kerry Berger. Welcome back. This is Got Family, and I am Kerry Berger. We're here with Stephen Ware. As you may have noticed, we left dangling one other question, which was, what about that Chapter 13? What's that one?
Well, the basic idea here is some debtors in bankruptcy have good paying jobs, and if they can just have a few years to earn their pay, they'll be able to pay a significant portion of their debts and not have to lose their property, not have to lose the boat or the car or whatever it might be. And so they have a plan. And the plan gets approved by the court, and the plan basically says I'm going to earn this much income and my expenses are going to be lower than what I earn, so there's some money left over to pay my debts.
Well, I guess that question then leads to, all right, great, I've got this plan. What about interest on all those debts? What about, how does that all work?
And that's the same line we saw earlier between secured debt and unsecured debt. Debt with collateral, those folks probably going to get paid in full. Your plan's going to have to pay the car loan and the home mortgage
Including the
loan in
interest.
full, including the interest.
Right.
Whereas those unsecured creditors without collateral, the credit card companies and the small business and so forth, you're going to be able to pay them a much lower percentage if you're the debtor in Chapter 13. So we don't necessarily distinguish principal and interest in the kind of technical way, but just to say much lower, maybe so low as nothing. In other words,
unsecured credit.
Yes, in other words, some Chapter 13 plans just pay zero to their unsecured creditors.
All right, now let's go ahead and wrap it up this way then. So what does this mean to the person who's now going down Chapter 13? Can they go ahead and still get the business relationships that they want to be able to run their business and continue to live while they're on the plan?
Well, you certainly can't stop. You certainly can't stop people from shying away from you. But what you often find is that you are more attractive as a future debtor to creditors who say, "Hey, this person is discharging the old debt in bankruptcy. I'm going to be the only debt. If I'm the new creditor, I'm the only person this debtor is gonna owe." So it's difficult to predict whether filing bankruptcy and discharging debt will make it harder for you in the future to borrow, or maybe easier.
Yeah. Well, we are out of time as it happens, so we'll have to just leave that question for another time. Will it be harder or easier? You've heard so many, all of us have heard so many truisms or concepts of, 7 years until you're able to be able to get a loan again or whatever. Unfortunately, most of those truisms or rules of thumb are about as good as your thumb is at measuring it. It doesn't necessarily mean a true answer.
Right.
Is that accurate?
That's correct.
And that is where we all live in so many ways. Here at the crossroads of business and family, we live at a place where we don't always have all the right answers, and we don't always have easy answers. We have to make our best guess and try to deal with things as they come along. And when they do, know that you're not alone. You've got resources within your own circle of influence, and you've also got resources right here on our radio show. And you ultimately, if you need to, you have professional resources that you should not be ashamed and not shy away from calling on. Sometimes it really is appropriate. Call your doctor, call your dentist and call your attorney if you need help. And that's what we're talking about here at the Crossroads of Business and Family today on the Got Family Radio Show. Look forward to seeing you again next week. And this is Kerry Berger on the on the Got Family Radio Show on thevoiceoflawrence.com.
For more information on Got Family, visit facebook.com/GotFamilyRadio. Check us out on Twitter @GotFamilyRadio. To leave a message for Kerry, call 844-GOT-FAMILY. That's 844-468-3659. This is Got Family Radio.